Mr. Gayer, good afternoon to you.
Thank you, Your Honor. Good afternoon to you. May it please the Court, again, my name is Rob Guy. I represent the insurance carrier in the matter of Collins v. Dukes Plumbing. As you know, we've split up the argument amongst the three of us. Basically, we've all argued the same thing, but we've divided it up. And I'm going to, and obviously you're aware that I'm hearing impaired.
Yes.
I might not actually hear that you're talking to me if I happen to be looking down or looking the other way, so please bear with me in that regard.
And we welcome your dog also. Go ahead.
Oh, thank you.
Mr.
Yes.
Gayer, on behalf of Dukes Plumbing.
I'm going to be talking about the statutory language in Workers' Compensation Law, Section 27.2, as well as Workers' Compensation Law, Section 15.3W. And it's our position that looking at the statutory language, that it's clear that the legislature intended that the mandatory deposit into the aggregate trust fund applies only to capped cases. When we look at the actual language of the statute, including the Reform Act, it's clear that the two work together. Under Section 15.3W, it clearly has been amended to apply only to capped cases. What the third department has determined and what the board has determined, that is what we're going to do is we're going to use the current Section 27.2 and we're going to use the old Section 15.3W to determine what carriers have to pay for claimants with a date of injury prior to March 13, 2007. And it's our position that the prior 15.3W and the prior 27.2 apply to the dates of injury prior to March 13, 2007. To do it otherwise, as Commissioner Paparocki has stated in her dissent at the board level, does not do justice to either of the amendments. You really can't have it both. You can't use part of one and part of the other. In the same token, we could also argue that all claimants with a date of injury prior to March 13th. Yes, Your Honor.
What about the statutory language? If any such award made on or after July 1st, 2007 requires payment, there's no exception to that. How do you get around that?
Well, Your Honor, I think what we're looking at here is we're looking at specifically at Section 15.3W as to what it applies as when you look at Section 27.2, it goes to Section 15.3W. Section 15.3W only lists the caps. The amended Section 15.3W makes no mention of anything other than the cap cases. So when it refers to the awards being made under Section 15.3W, it's specifically talking about those cap cases, not the cases in which the caps wouldn't apply.
Why is it an unreasonable interpretation that the appellate division gave?
We believe it's an unreasonable interpretation because essentially what we're doing, or what the Court is doing, is they're taking the old Section 15.3W and applying it to the new Section 27.2. And I mean, that's the only.
It makes no distinction between capped and uncapped, the old statute, correct?
I'm sorry, Your Honor, that didn't come through clearly. If you could. I'm not sure which portion you're talking about. Are you talking 27.2 or are you talking about 15.3W or both?
Both. I mean, generally, it makes no.
In Section 15.3W, it only talks about the cap cases. It makes no mention. It specifically talks about cap cases. There's no indication in there. It talks about the awards that need to be made when the caps apply, how many weeks the claimant would be entitled two awards, or in essence, how much would need to be paid into the trust fund.
The argument I think,
the
the argument I think is that that's used only as a means of identifying the non-scheduled losses.
Well, I don't think there necessarily are scheduled losses as far as the scheduled loss of use is normally determined here. But the payments that are required under Section 15.3W, those are the amounts that would need to be paid into the aggregate trust fund. If I might, in essence here, under the board's interpretation here, if the claimant has a date of injury of March 12, 2007, and another claimant has a date of injury of March 13, 2007, both of the claimants earn $600 a week. Both claimants are classified with a permanent partiality 2 years later. The one who had the date of injury in March 12, 2007, the day before the enactment date, the carrier is going to be required to make a deposit into the aggregate trust fund of over $200,000. The claimant who was injured the following day, the deposit into the aggregate trust fund is going to be about $50,000.
Yeah, but even, I mean, that happens all the time. I mean, in the grave, you know, the grave injury changes to under plenary actions when they talked about grave injuries. They said any cases filed on or after a certain date. So everybody scrambled and filed their cases before. But if you got there before, you were fine. If you didn't, you were not.
Well, it's our position here that when we look at Section 15.3W and we take a look at Section 27.2, and again, what the Third Department has done here, what the Board has done here, is they're taking pieces of each rather than looking at the statute as a whole. The current 15.3W has no indication as to what should be done in cases in which, and again, it's important to recognize that both of these were amended at the exact same time. So the legislature, in amending Section 27.2, also amended Section 15.3W. They could have very easily have indicated in 15.3W that the old standard for 15.3W, the old 15.3W would also apply to the new 27.2. They didn't do that. Yes, Your Honor.
Did the legislative amendment focus on the date of the award or the date of the injury in deciding which cases would be subject to the new deposit rules? I'm not sure I understood the question, Your Honor. If you could repeat that. I'm not sure. I thought the effective date amendment dealt with the date of an award as opposed to the date of the injury. Am I incorrect?
Yes, that is correct. It's the date of the classification, but I mean everything stems from the date of the injury. I mean the average weekly wage, depending on when the claimant was injured, the claimant would only be entitled to a maximum, the maximum rate that's applicable. All that's controlled by the specific date of injury. And we don't see anything in the new legislation to indicate that the legislature intended to alter what occurred with the cases when there was a date of injury prior to March 13, 2007. I see my time is up.
Yes, thank you, Mr. Gayer. Ms. Penna, on behalf of United Rentals, and I believe you've requested rebuttal time? Oh, I'm sorry. Okay. But who are you next? You, Ms. Penna? Yeah, all right. All right, let's wait to unplug all of them. Just wait a second. Okay. Go ahead.
May it please the Court. Good afternoon. My name is Jacqueline Penna, and I represent Ace USA.
Can you pull the microphone down?
Sorry. Is that better?
Yes, thank you.
I represent Ace USA in the Robinson and Parkhurst cases. It is the appellant's position that the computation of the present value of the ATF deposit is arbitrary and capricious because the actuarial tables cannot accurately predict the length of an uncapped award.
Are you assuming this, you're saying assuming the statute requires it, then if the statute requires the impossible, it's unconstitutional? Is that the argument?
The argument actually goes to this Court's decision in Burns, Your Honor, and I'm sure this Court is aware of your decision in Burns, and basically the decision.
Well, I mean, as I understand, in Burns, you can read Burns to say it can't be done.
Mm-hmm.
Now, let's assume that the legislature has said, we think it can be done, go do it. Don't we have to say, okay, on second thought, it can be done?
Well, Your Honor, you'd have to overrule your decision in Burns, because I think the principle in Burns is the same principle that would apply in this case. You cannot determine a permanent partial disability, how much money would be attached to that permanent partial disability, because the claimant could return to work.
Well, suppose we and the legislature disagree on whether this sort of calculation is speculative. Who prevails in that argument?
I would say this Court would prevail, Your Honor, because of the Burns decision.
Then you're really saying the legislation is unconstitutional?
Well, we are going to get into constitutional issues. Ms. Darling will be arguing those, yes. But as far as the Burns decision is concerned, the principle is the same that this Court decided in Burns. We have a similar situation. If any of these claimants return to work, the calculation would be 0.
That's not unusual, though. That happens in all the personal injury cases you can name. You know, people die, people get sick, people get married, people do all kinds of things that were not part of the original projections, and we just say that's life. Why wouldn't that apply here?
Well, it happens in all workers' compensation cases, too, Your Honor, and I believe that's what this Court's position was in the Burns case, that it's very speculative. The claimant could return to work with reduced time.
To the extent that you're right, though, why would this not be a legislative fix?
I'm sorry, Your Honor, I didn't hear you.
I said to the extent that you're right regarding the calculation, why would it not be more appropriately a legislative fix?
Well, I think that may go back to how Section 27.2 and Section 15.3W should be read together. I'm not sure what would happen with the Burns decision if the legislature's determination would overrule that, to be frank with you.
If the claimant went back to work for greater earnings than the award, are you able to go back to the Workers' Comp Board and to ask for an adjustment?
Well, it depends on if Section 27.4 would apply to uncapped cases. And I think there's an argument there that it does not apply, but let's assume that it does for argument's sake. The claimant, if I may give you a hypothetical.
Well, I'm wondering if you could go back and ask for a refund if you were able to show that the claimant now had earnings far in excess of the uncapped award.
Under Section 27.4, you can go back, but the question is whether Section 27.4 applies only to capped cases, of which these are not, or whether it would apply to all cases. It's our position that it only applies to capped cases, so then you could not go back and get a refund.
But if you lose the case and we hold that the statute does apply to the uncapped cases, then you can get the refund.
Well, there's still issues with the refund, because a claimant can return to work 1 week, the claimant could have surgery the next week. So the first week, the figure is 0. The second week, it's $400. After the claimant recovers from surgery, the claimant returns to work, and
you're saying there's a lot of practical problems in getting that refund, and you have to the monitoring may be more trouble than it's worth.
Well, exactly. The ATF, the Aggregate Trust Fund, is going to have to recalculate all of these, and it could be on a week-to-week basis. And there's definitely an issue as far as providing accurate, timely benefits to these claimants.
Okay, but the answer to Judge Graffio's question, if I understand it, theoretically, is if your adversaries prevail in this case, and the statute means what they say it means, then you do have the right to apply for a refund. You say there are all kinds of problems with it, but you have the right.
Again, it depends on how you read Section 27.4, Your Honor, and whether or not that section applies to both capped cases and cases that are not capped.
All right, thank you so much.
I see my time's up. Thank you.
Ms. Starling, on behalf of Landmark Chrysler, number 202. And you're asking for rebuttal time, correct?
I would like to request 1 minute of rebuttal time,
1 minute.
please.
1 minute out of your 5, okay.
Thank you. May it please the Court, my name is Karen Darling, representing Landmark Chrysler and Erie Insurance, and being in a position of speaking third and acknowledging that our arguments do overlap. I think what this in its simplest terms boils down to here is, did the legislature intend on having amended 27 to apply to dates of accident before 3/13/07? And we submit that the answer to that is no. And generally, statutes are construed as prospective unless the language of the statute either expressly or by necessary implication requires it be given retroactive application. And granted, Section 27(2), as amended, does indeed apply, per the language, to all permanent partial disability awards made after July 1st, 2007. But we submit there is indeed an ambiguity created by virtue of the fact that amended 27(2) expressly defines awards under 15(3)W as a new class of awards that required mandatory ATF deposits, yet 15(3)W, as amended in the same 2007 Act, provides for the first time a cap on permanent partial disability awards that did not exist before the amendment. And
I'm still having trouble seeing, on your theory, why did the legislature bother to write into the statute the words awards made after July 1, 2007?
I think the problem there is, although the express language of amended 27(2) is not limited in its application to a specific date of accident, amended 15(3)W provides a new and significant distinction in the practical application of 27(2), which is indeed controlled by date of accident. In other words, the capping of awards for accidents that occur on or after March 13th, 2007. And this distinction has a considerable impact on the practical application of amended 27(2), because for obvious reasons there's a substantial difference between permanent partial disability awards in pre and post 3/13/07 claims. And the legislative history behind the 2007 amendment notes nothing specific about the ATF provision, but two chief goals of the legislation were to increase indemnity benefit rates payable to claimants and also to reduce costs for carriers. And neither the appellate division nor the board panel.
It also was to protect consumers from the possible insolvency of a carrier in the future.
That is true, and I would acknowledge that the Workers' Compensation Board has always had the discretion to direct an ATF deposit with respect to permanent partial disability claims, including before these 2007
What
amendments.
was their practice? What was their usual practice?
As a practical matter, that was virtually never imposed before the 2007 amendments. I'm not aware of any decisions from this Court or the Appellate Division, Third Department, dealing with a direction for a discretionary deposit in a permanent partial disability claim.
I'm trying to understand the analytical path you want us to take here. Are you saying we should look at the Section 15 language and give that more weight than the effective date provision?
I think, in essence, that is what I'm saying.
Is that what it boils down to?
I think so. Turning back to...
And why should we do that?
I think because you cannot read 27(2) and 15(3)W separately. 27(2) expressly references 15(3)W. And I think what's troubling is that 27(2), I think what's troubling is that 27(2) is indeed controlled by the date of the award, but 15(3)W is controlled by the date of accident. And there's absolutely nothing in the legislative history really even addressing the substantial different impact that the legislation would have on pre- and post-3/13/07 claims.
Thank you, Ms. Darling. You'll have your rebuttal time. All right. Mr. Wu, on behalf of the Workers' Compensation Board, all three cases. Go ahead.
May it please the Court, Stephen Wu for the Workers' Compensation Board. Amended Section 27.2 unambiguously requires ATF deposits for any award for a PPD that is made on or after July 1st, 2007. We know this from a host of reasons, but it really starts from the text of the statute. It uses the broad phrase, any award under 15.3W, and it doesn't limit it to the pre-amended or the post-amended version of that statute. And there's no dispute here that both the pre-amended and the post-amended version of 15.3W continue in effect. We also know this because the legislature put in only one limitation to the statutory language, which was for awards made on or after July 1st, 2007, and did not place in any other limitation, so that limitation is an exclusive one.
Do we have the conflict between Section 15 and Section 27 that your adversaries are emphasizing?
There is not. Both of them can be applied in their plain language interpretations straightforwardly as the Board did here. All that it means is that the 2007 amendment provisions are triggered at separate times in the process of applying them.
Why? Why did they make that change? I mean, you work at the Compensation Board. Why would they make this difference?
Well, the reason is because really these are two separate policies here, and there's no logical reason that they have to be linked. The policy for the deposit is to extend the protection to workers' benefits. It protects against carrier insolvency. But that policy doesn't depend upon how long exactly or how capped or uncapped a particular award is. Rather, it just depends on the fact that there is a long-term benefit. And in fact, if anything, the need for a deposit is higher when there is a longer benefit like an uncapped award, because then the risk of carrier insolvency becomes greater. In 15.3W, the policy was to limit benefits for workers and thus to save costs in the system.
Did they get their money back?
I'm sorry?
Did the carriers get their money back? Let's assume the claimant dies, the day after the award.
They can get the money back under 27.4. And 27.4
not from death, though.
Well, death is a complicated situation.
Death is already taken care of in the actuarial calculation?
That's not necessarily the case. There are cases where when there's a death benefit, it will be offset by the amount of the deposit. But what I will say is 27.4 lays this out very clearly. There's an entire series of escalating provisions that apply to capped awards explicitly. There are some that apply to uncapped awards. But what we do know is that under 27.4, if there's a change in the amount of the award, then the carrier can get a refund back from their deposit, or they may be required to put in an additional amount of money if the deposit has to increase because of a reclassification.
And are you saying that there could be a good reason why the legislature actually chose to do it this way, to make the trust fund payments kick in effectively before the caps kicked in?
Yes, and the reason.
Tell me again what that reason is.
I mean, the reason is essentially that the legislature wanted to put in a protection for workers' benefits before it phased in a limitation on them. I mean, these are two separate policies that the legislature has pursued.
Wasn't it a trade-off? Wasn't it, okay, we're going to cap the benefits, but you've got to pay them up front?
It was not a one-to-one trade-off in that respect, and that is nowhere in the legislative history. In fact, I would question whether there is any necessary or logical relationship between a capped benefit and a deposit. One thing to note is that since 1935, there have been mandatory deposits for at least two categories of uncapped award, permanent total disability awards and certain death benefits paid by insurance carriers. So at least for 80 years, it has been true that the board has required deposits for awards that have no cap. And there's no legislative history that suggests that.
Well, because a total disability is by its nature more predictable than a partial disability.
That's not necessarily true. I think what's common between those two is the fact that the disabilities are determined to be permanent. And that's what enables the sort of present value calculation of these awards here.
Can I ask you, we have 3 cases here. What's the universe of cases that are similar? Are we looking at several dozen, or are we looking at thousands of these cases that fall between these two dates?
We're looking at several thousand cases. I mean, the board hears something like 150,000 to 300,000 cases a year. In the last 4 years, I believe the number has been at most 15,000 cases where they have classified workers who were injured before March 2007. So it is a significant number, but it is a fraction of the overall docket of the workers' compensation.
And eventually it'll peter out eventually.
That is correct. This is
How long does it take for a typical case? Because these took a particularly long time.
These can take a while. I mean, it really depends. One of the issues is that the board has continuing jurisdiction over workers' compensation cases really for the lifetime of the award. And so there may be cases where a worker is injured a decade ago, but it may take 5 or 10 years for the injury to be aggravated into a permanent disability or a total disability. And so it's hard to calculate exactly how long this will take. but this is necessarily a temporary problem.
Can you speak to the speculative nature of calculating these awards?
Yes. The Burns decision from this Court doesn't apply here because that was a case about the Court's own equitable apportionment of attorneys' fees. What it did not say was that the legislature or the agency was not able to make that calculation. And in fact, there's good reason here to think that the agency
Can't you read Burns as saying the calculation cannot be made?
I don't think it can be read that way. And part of the reason, in fact, if you look at the reasoning of Burns, one of the problems that this Court had was that the courts didn't have the power to come back and revisit the award if there were a change in circumstances. But that is a power that the agency does have under the statute, which is why it makes more sense for an expert agency to engage in a sometimes complicated calculation of net present value, as opposed to having the court do so as part of its equitable powers. I want to comment briefly on the constitutional claims that two of these appellants have raised. I think the common factor here that defeats these constitutional claims is the fact that the carriers operate in a highly regulated area, and more particularly that the deposit requirement here has always been a part of the law, not just —
But now it's mandatory. Can you mentioned 15,000 cases. I mean, is it conceivable that 5,000 of those are with one particular carrier and the initial hit would be rather significant?
It may be significant as a practical matter, but it does not mean that it is a constitutional violation. And I think that's clear from the Supreme Court's cases. I mean, just to give one example, in the Connolly case, which is a takings case, the Court acknowledged that the mandatory deposit there into the pension fund would require a quarter of the net worth of one of the companies there. But that wasn't enough because —
Do you regulate their premiums, though?
The insurance department regulates their premiums and sets those rates. And it takes into account, as it did in this case, what happens with the underlying statute. I mean, one interesting fact is that these premiums, in fact, went down significantly after the 2007 amendments because the net effect of the entire bill was to reduce costs to these carriers. But the fact of the matter is the workers' compensation area is so heavily regulated that, as the Supreme Court has recognized, it's impossible for the private entities operating in that area to have constitutionally protected entitlements to particular facets of it. And it's particularly true here because the deposit requirement has always been within the discretionary power of the board. And all that this legislation did was to take —
Are you saying then that comp carriers are completely at the mercy of the state? The state can confiscate them and anything it wants from them?
No, that's not what I'm saying. But in this case, where the deposit requirement is one that has always been within the board's power since 1913, it's one where I'm saying that the carriers cannot have a constitutionally protected entitlement. Thank you.
Okay, thank you. All right, Mr. Gray, on behalf of Claimant Collins in Case 203.
Thank you, Your Honor. May it please the Court, I'm Robert Gray. I'm appearing on behalf of Respondent Collins. I'd like to spend a little time addressing the policy concerns that some members of the Court have expressed. The Court is, of course, aware that the basic purpose of the Workers' Compensation Board is to protect the injured workers of the State of New York, and this is a redistributive piece of social legislation. The policy decision —
That in itself suggests that every claimant always wins every case. It's got to be more complicated than that.
Well, Section 10 provides some limited defenses for carriers, Your Honor, and as long as they have a Section 10 defense, they can win. The policy underlying the ATF deposit was a decision by the legislature that insurers needed to be encouraged to engage in settlements. And the way the legislature did that was by reforming two sections of the statute. One section was a requirement mandating carriers to make settlement offers when the injured worker is found to be permanently disabled, and that being the carrot. And the stick was that if the carrier fails to arrive at a settlement, then the statute now requires them to give the money to the aggregate trust fund.
Why do they choose to hit the donkey with the stick for several months before they give him the carrot?
Well, actually, Your Honor, it's the other way around. When the reform legislation was passed, the statute provided a 120-day window before the mandatory aggregate trust fund deposit became effective. So the insurers were put on notice that they had a window of opportunity in which they could seek to classify and settle these uncapped permanent partial disability cases before the legislation would become effective. From a broader policy standpoint —
If you settle it, what happens?
If they settled, then they settled.
I mean,
There's no deposit?
Then there's no deposit. If they settle with the claimant, then they need not make the deposit to the aggregate trust fund.
They could settle with the claimant for the exact same injury, the exact same percentage beforehand, and just not have to do a deposit?
Well, no, it's actually an interesting question that isn't raised by these cases. These are all cases where the worker was classified permanently disabled after the effective date of the Section 27 amendment. So both classification and payment of the award occurs after the mandatory deposit date. That date, however, was not for 4 months after the statute became effective. If the court had a case where the carrier had pursued classification between March and July and had the claimant classified permanently disabled before the effective date, then there would be an argument that the carrier was not subject to the aggregate trust fund deposit because the classification was prior to the effective date.
But like today, if somebody was hurt, the carrier would say, let's settle with you because we don't want to make a contribution to ATF?
That's right.
That's rather coercive, isn't it?
Yes, but apparently that was the judgment of the legislature that that level of coercion was required to move these cases through the system and to obtain fair settlements for insurance.
They're all subject to approval, I assume. I mean,
they are all subject to approval of the Workers' Compensation Board. There is, if I may add, however, a broader picture here, which is that this provision was not the only provision of the 2007 legislation.
So what's the benefit to the carriers, if any?
In this particular section, the benefit to carriers in this particular section is that carriers are better off settling cases than not. You know, carriers are required to maintain reserves. They're subject to regulation by the insurance department. It has been demonstrated that permanently disabled workers tend not to return to work, and if the carrier fails to settle the case, then they pay the injured worker on an ongoing basis.
If they have a Section 10 defense, they then assert that defense at their peril?
If they have a Section 10 defense, then the case is contested ab initio, and we never, and if the carrier is successful, we never reach this.
But if he's not, in other words, the carrier says, I don't think he was on the job at the time that he was claiming to be injured. But if I contest that, I'm buying into ATF because I can't settle it, right?
No, that's not correct, Your Honor. This statute applies only after the compensability of the claim.
After a finding?
Yes, after it's been determined. But, you know, what the Court has here is a Reform Act that had 82 sections. We're dealing here with one of 82 sections. So while this particular statute may or may not impose additional costs on insurers, and we would submit that it's debatable whether it does or does not, there are other provisions of the same reform statute that substantially reduced costs for insurers, and the insurance department reduced premiums by 20% as a result of the overall reform legislation. So, you know, this was, in our view, clearly a legislative determination, and it was the judgment of the legislature that taking all of these pieces into account, this legislation would reduce employer costs. Although
Just finish up.
Yes, Your Honor. My red light is on.
Red light's on,
Thank
but
you.
I'll let, oh, okay, fine. All right, Ms. Darling, a brief rebuttal.
Just speaking very briefly on the issue of the settlements, I think this ties back into the Burns argument that under our Burns argument, in the speculative nature of calculating permanent partial disability awards and uncapped claims, that then turns into the speculative nature of the deposit based upon life expectancy and the speculative nature of the carrier's ability to make a settlement offer. The Board has held, specifically in the matter of Buffalo Auto recovery case that we did cite in our brief, that pre-reform WCL Section 15.3W provides only potentially unlimited or lifetime compensation. The Board has explained that a determination that a claimant has a permanent partial disability does not automatically entitle him or her to a lifetime of benefits. For example, as we've mentioned, the claimant can remove him or herself from the labor market. A claimant can go back to work with reduced earnings. A claimant could potentially be found to have committed fraud. Thus, potential compensation is not a property right vested in the claimant by the mere determination that a claimant has a permanent partial disability. And one final point on the issue of settlements. Once a carrier does make a deposit into the aggregate trust fund, the aggregate trust fund can then turn around and settle out the claim for less than the amount of the deposit, which then ties into the constitutional.
Practically speaking, when you're talking about that, a carrier is making, I assume, hundreds or thousands of contributions to the ATF. I assume it's in one check. I assume that there's a settlement at some point where you kind of, where the ATF tells you how much you got in and how much you owe, et cetera?
Generally, that once the claimant is classified with a permanent partial disability, from that point, the carriers are given 6 months to make the deposit, and then the amount of the deposit is determined.
But what you lose on the grapes, you can make on the bananas in a sense. As you mentioned, you may have paid too much on claimant A, not enough on claimant B, and you can adjust that within your account.
I really can't speak specifically as to how that occurs. I'm not sure.
Thank you so much, and thank you, all of you.